the beginning. Today, I would like to talk about the practical issues which companies operating business in Russia, local companies and foreign companies faced in these hardest times and in the circumstances when of COVID-19 outbreak and further state restrictions imposed outside Russia and inside. So in this presentation, we will talk about on whether the COVID-19 circumstances can be regarded for the companies as a force majeure under the Russian law, and how it can help to the business to avoid negative circumstances with respect to their contracts, and whether this qualification will not help, but other instruments may help, in fact. So let's start. Could you please turn the next slide? Force majeure under the Russian law, it is something unpredictable that unforeseen and comes to the parties' relations, let's say, outside, and has an influence to their relations and their contractual obligations. In terms of the Russian law, force majeure circumstances can be regarded as this fact only for the contracts concluded, executed before this circumstance happened, unless the criteria of being unpredictable does not work. And force majeure circumstances, it is something extraordinary and something that parties did not expect and cannot somehow overcome because it comes from outside. To sum it up, this is something very exceptional for the parties. I would say that the key thing in the notion of the force majeure under the Russian law, which has a certain practical meaning for the contractual relations, is the criteria on that these circumstances shall be unpredictable. Due to this criteria, the contracts shall be regarded as risky contracts which will be concluded close to before state limitations and restrictions imposed in Russia. I mean close before to March of this year. With this contract, the criteria of being unpredictable can be questioned because notwithstanding the fact that in Russia at this time no restriction measures were imposed and generally epidemic situation in the country was more or less good, at least the official level. There were lots of negative consequences, restrictive measures in the world, in the countries close to Russia, and in this situation, it can be the counterparty can be argued that even there were no. Even the situation in Russia was not so bad at this time, but the general world situation could be treated as that situation will be worse in Russia very soon. Unfortunately, we still do not have any examples in the court practice regarding this topic I mentioned, but it would be very interesting to see in the future whether such cases will be considered in the court and what court would say about this situation. We will see. Could you please move to the next slide? The very interesting and important thing under the Russian law is to tell about circumstances which are not considered as a force majeure under Russian law. The issue is that due to COVID-19 outbreak, lots of companies had practical problems, lack of funds, close of operations, problems with their counterparties, their subcontractors and other persons on whom they depend and in performing their own obligations. The tricky thing is under the standard approach, which is provided in the Russian law, such circumstances are not regarded as a force majeure circumstances. For example, lack of goods on the market, which are needed for execution of an agreement, absence of necessary funds to pay for something under the contract, breach of obligation by the counterparty, certain entrepreneurial risks such as illegal actions, bankruptcies, and others listed on this slide. So this is how it should work under the Russian law, and obviously it makes a problem for the companies, for the Russian companies and the foreign companies operating in Russia currently. These exceptions are the key problem in this particular situation connected with COVID-19 outbreak. And you may see on the slide that regarding absence of funds, we marked it as update because in the spring, Russian court made a review of the current situation with COVID-19 from the legal standpoint, and made very important update and clarifications on this matter, which would definitely help to companies which are in a very bad condition currently. The next slide, please. Could you please move? Yes. The important thing regarding the clarifications about COVID-19. These clarifications were made by the Supreme Court of the Russian Federation in spring. For sure, I shall mention that under the Russian law, clarifications of the courts, clarifications of Supreme Courts are not regarded like court precedents in the common law system. But anyway, in the practice, all the businesses, all the parties, all the relations, contractual relations, for sure, consider such clarifications of Supreme Court as it is some kind of a guidance for the courts when they will be considering exact disputable cases. So it's important and it shall not be ignored. First of all, the Supreme Court of the Russian Federation clarified that the force majeure, it is not something which works automatically for all the companies faced some bad times, currently face some bad times. Force majeure shall be determined and identified for each particular contract, for each particular circumstances under this contract for the parties. Frankly speaking, this clarification, it is not something new. It comes from the provisions of the Russian Civil Code, stating exactly the same. But anyway, this clarification clarification of the Supreme Court was negatively was treated negatively by the business, as this clarification additionally confirmed that it will be so hard for the business to confirm force majeure circumstances on this requirement case-by-case basis, and therefore exit from the liability for breach of their obligations and exit from liability for certain breaches. And the second important thing, which was clarified by the Supreme Court is about lack of money, which we mentioned on the previous slide as something that that cannot be regarded as a force majeure under the Russian law. The Supreme Court clarified that lack of money in this particular situation of COVID-19 negative consequences potentially can be regarded for as a force majeure, allowing the company to not to be liable for breach of their obligations. It is something new and very important because absence of lack of money, I would say this is the most the biggest problem which currently companies faced in Russia due to close of operations. But for sure, as the Supreme Court mentioned, again, it is something which does not work automatically. Maybe you know that company that Russian authorities adopted a few acts, lists of companies working in the industry significantly damaged by COVID-19 outbreak and limitations. But anyway, even the company operates in this kind of business and officially can be recognized as damaged. It does not automatically allow to this company to refer to force majeure circumstances and lack of money. Such condition, financial condition shall be proved by documents, by financial statements, and etc. So, and if it's impossible and the company is not successful to negotiate this issue with the counterparty without court dispute resolution, for sure, this issue can be resolved, in fact, only by the court. Could you please move to the next slide? The impact of force majeure. Even if we imagine the situation that the company is successful to prove that the current COVID-19 situation and consequences caused by COVID-19 are regarded as a force majeure for the company's contractual obligations, it's essential to understand that according to Russian law, qualification of the situation as a force majeure allows the company only to exit from the liability for non-fulfillment of company's obligations or total non-fulfillment, or, for example, non-fulfillment in parts. I mean, some delays, some minor non-payments, etc. So it's important to know. It's important to understand that for force majeure allows to just exit from the liability, but it does not mean that the obligation is automatically terminated and the company is fully free. Termination of the obligations of contracts due to force majeure, it's a separate, very, let's say, interesting issue according to the Russian law, and we will discuss it a little bit later. What could help to finally cancel the contract, for example, which in the current situation already became a real burden for the company. Could you please move to the next slide? The next topic I would like to briefly cover is how to prove force majeure circumstances in the coronavirus context. There should be a few steps to do so. First of all, the company should check the agreement for the force majeure clause and for special procedures to regulate relations between counterparties in case force majeure happened. It's important to double check the specific provisions, including due to the fact that potentially Russian law allows to expressly state in the agreement that the company will be still liable for non-fulfillment of its obligations, even force majeure happens. I shall mention that it's not widespread on the practice, and in our practice, I would say we almost do not see examples of such contracts, but anyway, it's important to double check. The next important thing, which currently, as the bad situation already happened a few months ago, may not be an issue currently now, but it's some kind of tip to be remembered for the future, especially considering the fact that all the countries potentially expect the second wave of COVID-19 outbreak in the future, and we cannot exclude that restrictive measures can be returned once again to our life. This is about notification. It's important when force majeure happens, it's important for the counterparty which faces some problems due to that and faces impossibility to perform its obligations. It's important to notify the counterparty on the agreement about the situation happens. It is very important because if the company does not do this, the company will lose the right to refer to force majeure circumstances when negotiating the problem situation which happened and trying to exit from the liabilities. The second important thing is to collect evidence. According to the practice, evidences proving force majeure and its impact to a particular contract shall be collected and presented by the company which faced problems with fulfillment of their obligations, but for sure not by the counterparty which is just waiting this performance. Evidences can be different. First of all, the most obvious and standard evidence which comes to mind when we talk about force majeure, it is a certificate of the trade of the Russian Chamber of Commerce and letters of the chambers of commerce, which is something new in the Russian practice. I will tell about this a little bit later. This is the first, but already talking about it, I shall mention that this is one of the evidence which in the current reality and the current Russian practice, it can be really problematic to get such a certificate. So just we think it shall be clearly mentioned, just the company shall not have large hopes about that. The next evidence is a letter to the counterparty describing force majeure circumstances and describing how the circumstances impact to the company and the company ability to perform its obligations under the contract. If possible, it's also recommended to use as an evidence acts of state authorities which confirm that certain restrictive measures interfere in the company's activities were imposed. If we talk about Moscow, for example, mayor's decree can be submitted. If we talk about other regions of Russia, it should be a decree of heads of other regions, because as you may already know, restrictive measures imposed in Russia due to COVID-19 outbreak were not imposed totally as at the country level. As the president mentioned at the beginning, each particular subject part of Russia may determine their own volume and number of restrictive measures in the region, depending on the epidemic situation in this specific region. So it may differ from one region to another. For example, measures imposed in Moscow will be and may be significantly differ from the measures and limitations imposed, for example, somewhere on the Far East, for example, in Vladivostok. And the last important thing to prove is a link between force majeure circumstance and non-fulfillment of their obligations. This is directly relates to what I mentioned before, that force majeure circumstance, it is not something can be used automatic to any agreements in the current situation. To provide some example, certain companies face real problems currently because their operations were fully stopped starting from March, and they were not unable to operate and gain some money. For example, restaurants, cafes, retail shops which sell goods which cannot be regarded as non-essential, as essential. So these companies are really faced the bad times. In the meantime, there are lots of companies which in fact do not feel a real impact of the current restrictive measures to their business. For example, food retailers and retailers selling other goods which are officially regarded as essential for population, and which were sold everywhere, even during these hard times. So this link, in fact, should be really proved in order to avoid abuse of options and abuse of rights to get something and to avoid from the liability, even the company really was not impacted and stays in a good condition. Could you please move to the next slide? Certificate of the Chamber of Commerce. As I already mentioned at the beginning of our meeting, I think that this part is one of the most important in our presentation, because for sure, for certificates of a Chamber of Commerce, it's the main document which comes to mind when we talk about force majeure. But there is a certain practical issue of getting these documents in Russia. Certain issues are, I would call them normal, as they lead from the legal regulation of standard legal regulation in Russia, and some of them, I would say, this is something practical and new. If we talk about certificates by the Chamber of Commerce in Russia, the Chamber of Commerce, when I talk about the Chamber of Commerce in Russia, first of all, I mean the headquarters of this chamber, not the regional chambers operating in Russia. The headquarters of the chamber authorized to issue so-called certificates on force majeure circumstances, which as a general rule can certify only force majeure circumstances happened on the territory of Russia. So if a company would try to get a certificate confirming force majeure circumstances and its impact on the business, for example, in China or in Italy, the company will be not successful and will get a refusal. Such certification shall be obtained in the relevant Chamber of Commerce of the applicable state. And the second important thing about these certificates, that the Chamber of Commerce is authorized to certificate force majeure circumstances only for foreign trade transactions, when the one counterparty is a foreign counterparty. When we talk about local Russian contracts, well, all the performing parties are Russia, or companies incorporated in Russia. The headquarters of the Chamber of Commerce will not issue certificate for such contracts. And at the beginning of COVID-19 outbreak, it became a real problem for Russian companies having local Russian contracts, which they were unable to perform. After this situation in March started, the Chamber of Commerce came with the help to Russian companies and Russian local contracts on this matter. It happened when in March the Russian government addressed a recommendation to the Chamber of Commerce to help the business with Russian local contracts faced with negative consequences, and to do this help by providing so-called conclusions on force majeure circumstances. It's not the same documents as a certificate. It is this conclusion. It's just something that can be issued just for local Russian contracts. It is important to say in this case that previously, before COVID-19, issuance of some conclusions on the force majeure circumstances under the local contract was not possible. We have official letters from the Chamber of Commerce, which were issued by the headquarters to the local chambers, for example, in November of 2019, where it was expressly stated that the Chamber of Commerce, local chambers of commerce, shall not issue such conclusions on the force majeure under the local contracts. And the headquarters argued in this letter that if counterparties has some problems with the local contracts linked to force majeure circumstances, they shall negotiate it between themselves, and if they are not successful, to come to a court for the dispute resolution. And as of November 19, the only way how the local chambers of commerce could help under the local Russian contracts is to issue so-called conclusions on whether the company, the counterparty, performed its obligations under the agreement in a good faith. We saw examples of such conclusions, and in these documents, Russian chambers, local chambers, considered the situation happened around the contract in question, and just they do not consider the situation in question whether it's force majeure or not, but just states whether a particular company in breach in the particular situation in question acted in a good faith. This is what was only available. But as of March, as I already mentioned, after the recommendation of the Russian government, the situation was changed. The headquarters of the Chamber of Commerce officially stated that local chambers are authorized to provide Russian business under the Russian local contracts with such conclusions. And such conclusions shall be used just as one of the evidences when companies fail to agree on something amicably regarding the agreement and come to a court. So this document, for sure, together with a certificate on force majeure, shall not be regarded as something, okay, I received the certificate, and it automatically means that I'm free. I'm exiting from the liability. It does not work like that. Even in the Russian contracts, as I think lots of participants could see in practice, in Russian contracts, it's possible often to see a statement that the force majeure circumstances the parties shall confirm by the certificate issued by the Chamber of Commerce. In practice, lots of companies treat this provision of the agreement like if a counterparty does not get this certificate, it means that company has no options to exit from the liability. And frankly speaking, there are some examples in the court practice confirming such approach. But if we come and look at the general Russian civil law legislation, we may state that I would say that it's not clear, it's not correct, and it's not fair approach. And we hope that current new practice regarding COVID-19 will show something new regarding this topic. And regarding certificates, I would like also to tell about certain practical issues which companies currently faced. Even the headquarters of the chamber confirmed that such conclusions may be issued. According to the statistics, during these spring times, local chambers, at least Moscow Chamber of Commerce, received more than 2,000 applications to get such conclusions. And around 70% of such applications were rejected due to different reasons. Some certain reasons, to my view, could be quite fair and reasonable, and some of them should look, I would say, a little bit strange to me from the legal standpoint, and considering that the Supreme Court issued certain clarifications on this matter. I would like to tell about it because it's really important, especially due to the fact that these clarifications about reasons for rejection are officially placed on the website of the Moscow Chamber of Commerce. First of all, the chamber says that lots of they reject to provide conclusions often because of the fact that due to formal reasons, I would say, because companies do not provide a full package of requested documents, or which do not allow to the chamber to fully analyze the situation and come and judge that the force majeure circumstance happens. The next reasons is that the chamber does not see force majeure circumstances in certain situations which already happened for the companies during the spring times. For example, it's expressly stated on the website on the clarifications that the close of the restaurants, mandatory closure of restaurants, retail shops, etc., cannot be regarded as a force majeure. I was very surprised about this clarification. I just hope maybe it was about the wording presented on the website, and maybe in this written publication some very important details or clarifications were hidden, while because I do not understand if this is not the reason, what else? Or, for example, the Moscow chamber states that lack of funds cannot be regarded as a force majeure. For sure, from the pure legal standpoint, in this part they are correct, as we already discussed it before. But this clarification was published in May, when the Supreme Court already stated that the lack of money can be regarded as a force majeure in certain particular cases. So the chamber says no, while the court already said before that there is some hope if you prove. So, and this is the issue. And the third issue is that at least Moscow chamber refers that they reject to provide the conclusion on a force majeure for the contracts which do not have force majeure clauses in the agreement. It's a really important thing from the practical standpoint of view and from the legal standpoint, because for sure there is a small percentage of contracts which do not have such clauses inside. It's not normal, and it's not standard situation when the companies do not have such a clause in the agreement. For sure it should be. But anyway, this approach is quite interesting because under the Russian law, force majeure circumstances allow to exit from the liability just because it's written, it is written in the law. It does not work only if cases when the force majeure clause is directly provided in the law. When, for example, companies, if you imagine that somebody forgot to include it inside the agreement, we believe that in this case, force majeure situation shall be considered based on the standard Russian civil law provisions. So, but anyway, this is a position, and all these clarifications and this situation just may bring us to the conclusion that it may be not so easy to get such a certificate. But the positive thing is already confirmed in the practice, which we will see also on the next slides. And by the clarifications again of the Supreme Court, that these certificates shall be regarded in the procedures is one of the evidence to prove force majeure circumstances and its impact and inability to perform the agreement. So even a company do not have such a certificate, still there is a hope to get something. On this slide, I will, as we are quite limited in time, maybe I will will tell about this slide shortly. Then about the certificates. As I already mentioned, force majeure clauses do not automatically allow to a company in breach to exit from execution of the agreement, which was not fulfilled due to COVID-19 circumstances. Russian law states that in case of force majeure, such total termination of the agreement is possible, but according to the law, it's directly allowed for the creditor of the company in breach when the creditor understands that if some more time passes, it would be not interesting for the creditor to have this performance. For sure, the business often has questions why it's not fair and why this right provided only to the creditor, because the debtor also maybe would like to terminate this agreement, which will be a real burden for a company. So such right for a debtor may be provided directly in a contract, for sure negotiated with a counterparty and included to the agreement. We will talk about it a few minutes later in details. But the Russian law, in addition to provisions relating to termination of agreements due to force majeure circumstances, also have other options to exit from the agreement. Such options are listed on the slide. This is the amendment of the agreement or its termination due to substantial change of circumstances. Substantial change means that something happened after the contract which was concluded, and this what happened has a great impact on their contractual obligations. And if the company could know that these circumstances would happen, company would not execute the agreement on the such conditions as it was concluded. The next option is a termination of obligation due to impossibility of its performance. It directly correlates with the force majeure and other circumstances of inability to perform obligations which, for example, cannot be regarded as a force majeure, as the Russian law has a few groups of impossibility to perform the obligation, and the force majeure is just one of them. There are also other kinds of impossibilities which could help a company to exit from the liability and ideally from the contract. For sure, the easiest option, I would say, is to amend and to terminate agreement by mutual agreement with the counterparty. When I say easiest, for sure, it's not about negotiations with the counterparty, which can be really hard, but it's about the fact that if a company is successful to negotiate the termination amicably, it's easy because it will not require application to a court and wait a decision during a long time. And for sure, take expenses for the court dispute resolution. And the last key option which can be used is a suspension or termination of a counter obligation. It can be helpful in a case when under the agreement counterparties have counter obligations to each other, just not one party is regarded as performing. Just to sum it up, I would say that before COVID-19, in the practice, it was not so easy task to use this article in the court proceedings to prove to terminate agreements with the reference to the clauses. I mean here. There was not so much of positive practice. But the Supreme Court clarified that due to COVID-19, it would be COVID-19 situation opens the room for more wide implementation, for example, of the first change. Of the first option to change or termination the agreement due to substantial change of circumstances. So, and the last point, which from the practical standpoint, I would like to mention that exiting, there is no unified and universal rule to which can be used by each and every company in the current situation. It's important to analyze each particular case, what happened, what can be happened in the future, and to based on this analysis determine the strategy for contract negotiation. Could you please move to the next slides? Regarding the practice, I will try to be brief about the practice, because first of all, practice regarding COVID-19 just happens, and mostly this is decisions of courts of so-called courts of first instance. It means that potentially these decisions may be challenged in the higher courts, and decisions presented potentially may be amendment. But what is interesting in the practice already available, still there are lots of refusals for companies in breach. The reasons of refusal are mostly that the company did not prove force majeure and its impact on the company's business, or reasons of the next very popular reasons of refusal is that companies try to avoid liabilities under the contract, which in fact happened for them before COVID-19 outbreak and COVID-19 limitations. And the connection of their breach and the COVID-19 circumstances was not clear for the judge. That's why they rejected the claims. If we talk about positive cases, it's important that courts really try to take into account that companies are considered as operating of businesses which are officially regarded as significantly damaged by COVID-19. Companies really consider whether courts really consider whether a company is in a bad financial conditions because of restrictions, limitations, closure of operations, and other real financial reasons. They take into account, and we see examples of positive decisions when court confirmed that company, for example, may not pay penalties or will pay penalties in the reduced amount because company was really impacted by COVID-19. The next slide, please. And maybe one more, because I would like to be shorter so that we could have time to answer the questions. The last part of my speech shall be about practical issues. I would say lessons for the future, because the current, let's call it COVID-19 crisis, showed that in fact, first of all, business was not ready for such strict measures, and agreements were concluded before. They do not really cover all the particular issues which happened in practice just now, and maybe it's an issue of before it was unpredictable that someday it may happen in the reality, but it happened. This information and these tips for the future, for sure, it's already not the case for the contracts which are currently signed and in place. Only if companies decide to negotiate force majeure clauses, taking into account the current negative experience with it. It's just about contracts which will be concluded for the future, as the reality shows that force majeure risks really happened in this world now. So first of all, it's important to expressly define whether the force majeure, what circumstances will be regarded as a force majeure for the company, and which will allow company to exit from the liability. I mean, epidemic, wars, earthquakes, etc. So it shall be expressly as much as possible defined. If somehow companies agree that force majeure circumstances shall not be an excuse for them in performing their obligations, it shall be already written in the agreement, unless it will not work. The next important tip is to provide, again, for sure, I shall make a disclaimer, all these recommendations, for sure, it's up to negotiation with your counterparty. This is not something you could insist unilaterally. So for sure, it's up to the agreement, but at least it's something good to know, to at least to try to negotiate. So the next important tip is to provide the right to not only for the creditor but also to a debtor company to terminate the agreement if force majeure circumstances and its impact lasts a long time. Just to not make a contract a real burden for the company in breach. The period for notification regarding force majeure circumstances shall be also indicated. In practice, we see that this term often is provided as just a few days. But considering the current situation and current experience, maybe it makes sense to extend this term for notification, just to allow parties to understand where they stand and what happens in the country and how it will work. Because this current situation shows that the situation may change so fast. Another tip is to provide in the agreement other excuses for a company to allowing to exit from the liability if a company cannot perform its obligations. What I mean, according to the classic approach of the force majeure I already mentioned, a breach of subcontractors is regarded as a commercial risk. It can be regarded as a force majeure, allowing the main company, the contractor, to exit from the liability. But the real life and the business shows exactly in the current times that lots of companies, in fact, became in breach exactly because of force majeure and difficult times happened for their subcontractors. According to the standard approach, in this case, the main contractors cannot refer to the force majeure, but the Russian law allows to refer to them to other, let's say, excuse. In the current situation, this is other type of inability to perform the obligation. It's not widespread in the current contracts we work in our day-to-day life, but potentially it's possible to directly indicate in the agreement that the breach of a counterparty, for sure, not all kinds of breach, but significant breach caused by some kind of significant circumstances, like COVID-19 limitations, shall be regarded as an liability to perform the obligation for the main contractor, and such an ability shall be excused for the main contractor. For sure, it will not work for all the circumstances of breach. It would not be fair. It shall be regarded as like an abuse of a right. But for some exceptional cases, it could be and it should be, we believe. And as far as I understand, we have just the next slide, and after that, I will be happy to answer the questions and to discuss some hot topics. The next very important tip is regarding a question. What happens with the deadline for execution of an obligation which was suspended by the force majeure circumstances and due to inability to perform obligations, for example, during 1 month, 2 months, or even more. From the Russian Civil Code, I would say that from the logical standpoint of view, the deadline for execution shall be extended for the time when a company was unable to perform this obligation. But frankly speaking, it doesn't clearly expressly follow from the provisions of the Russian Civil Code. That's why our recommendation for all companies negotiating commercial contracts is that it should be expressly written in the agreement that if company, for example, is unable to perform obligations during 1 month, the total deadline for execution of the obligation by the company shall be extended for this month, which was lost due to force majeure. And yes, this is the last point about the tip with the subcontractor and partners. This is also, as I already mentioned, very important. So that's it. I hope it was useful. For sure, the topic of COVID-19 consequences, force majeure, breach of obligations, and what to do with the contracts, it's a really big topic which not possible to cover in the format of webinars. But I hope that this information presented by me today was helpful just to understand where to move, what's potentially possible to do, and what to consider for the future, just to avoid such negative circumstances like the business had today. Thank you very much.
Elvira, thank you very much for that really insightful and interesting presentation on force majeure. You've brought out some very unexpected sort of consequences of it, which I was unaware of. Unfortunately, we're pretty much out of time, but I think we have time for one question, and that was posted on the chat, and it was, how difficult is it for a UK company to apply for a force majeure certificate? And I suppose it's asking, is there any differentiation between foreign and local companies?
Okay, clear. Thank you very much for the question. I would comment like this. If a UK company would like to get a force majeure certificate regarding force majeure circumstances happened in Russia locally, it can be possible, potentially can be possible, but taking into account all the practical problems and formal requirements to be observed, I mentioned in the presentation. Because yes, under the law, companies have opportunities, have rights, but in practice, reality differs a little bit, and in practice, it's not so easy like it may look like. So therefore, when we talk about local Russian force majeure for an international contract or for a local contract, potentially it's possible, but it's about the details, it's about due application, and about the final decision of the chamber. But if we talk about certification of some certain circumstances happened outside Russia, for sure, Russian chamber will not help with it. They would reject.
Okay, thank you very much, Elvira. Unfortunately, that's all we have time for, but I'm sure, as you very kindly offered, we will make your presentation available for people should they want it. Also, as I said before, we will post the webinar on the website, and I'm sure you'll be happy to field questions offline should people...
Sure. Sure. There are my contacts on the last slide of the presentation, and so if you have some, please feel free to send me a message or the question.
Okay, so thank you very much to Elvira, to Mazars for providing such expert advice on such an important topic. Thank you to all the participants who have taken time to join us today. And I'd just like to remind you that the webinar series continues next week. We have two events, one on Monday, which is with Sterling Woodrow, which is a big property firm, discussing some of the issues that have been thrown out by COVID-19 with respect to property. And then on the 23rd, on Tuesday, we are very privileged to have the British ambassador join us once again with the head of the Department for International Trade in Moscow. And they will be here to answer your questions on the COVID-19 situation and how that's developing. But anyways, for today, thank you very much. Please join us next week. And one final thank you to Elvira and to Mazars. Thank you very much and have a good day.
Thank you. Thank you very much.
Thank you.
Thank you.